Let me turn now to introduce the 2022 Kirby lecturer. Professor Anne Orford is an ARC laureate professor at the University of Melbourne and Michael D. Kirby Chair of International Law at the law school there. She's also visiting professor of law and John Harvey Gregory lecturer on world organization at Harvard Law School. She's been a visiting professor at Paris 1, the Sorbonne, Lund University, and the University of Gothenburg. A senior Emil Knoll Research Fellow at NYU School of Law, and presented a special course at the Hague Academy of International Law in 2021. Anne is a Fellow of the Academy of Social Sciences in Australia and a past president of ANZIL, the Australian New Zealand Society of International Law. She's also currently serving as a visiting legal fellow at the Australian, at DFAT. She is an accomplished, hugely cited, well-written author. She's made a lasting contribution to legal scholarship. Her books include the recently published and widely acclaimed International Law and the Politics of History. It's a Cambridge University Press publication from 2021. International Authority and the Responsibility to Protect, Cambridge University Press 2020. Reading Humanitarian Intervention, Cambridge University Press 2003. I don't think I've ever introduced anyone before who had 3 Cambridge University Press books. We invited Anne to speak this evening because her work is rigorous, creative, historically informed, and rich with policy implications for contemporary legal problems and challenges. I've only just given you the briefest of outlines of her honours and accomplishments, but I'm going to call on her now to deliver the 2022 Kirby Lecture.
Well, many thanks, Dean Wheeler, for that introduction. Thanks also to Leighton MacDonald and Sippel for the invitation to present this lecture, and to Charlene van der Valk for all the work she's done arranging the logistics and the marketing, not just for this lecture, but for the ANZIL conference, which is also ongoing over the next few days. And I would like to join with Dean Wheeler in acknowledging the Ngunnawal people, the traditional owners of the land on which we're meeting, and pay my respects to their elders, past and present. I just realized I can't see a clock. So if things go wildly over time, just wave at me. As a visiting legal fellow at DFAT, I also need to make clear that any views and opinions I express in this lecture are mine and do not necessarily reflect the views or opinions of the department or the Australian government. I feel very privileged to join the long line of international lawyers who've been invited to present this lecture, established to recognise and honour the work of Michael Kirby, and I'm very pleased to be able to see him in person again tonight. I've also since 2009 been the holder of the Michael D. Kirby Chair in International Law, and there have been 2 unanticipated benefits of holding that chair. One is the encouragement that Michael has given me since my appointment, taking time to write generous emails when he hears news about projects on which I'm working. And the other has been the experience of being approached in many different parts of the world when people notice the name of my chair, wanting to tell me how important Michael has been as a source of encouragement in their lives and how much they value his contributions to international law and human rights. So the topic of my lecture is why it's time to terminate the TRIPS agreement, that is the agreement on trade-related aspects of intellectual property. And I chose that topic in part because it draws on the book I'm finalising, entitled The Battle for the State. And that book explores how the complex interaction between democracy, international law, and economics since the end of the Cold War has shaped what the state is, who it can represent, and whose interests it can protect. And I believe if I say it often enough that I'm finalising this book, one day that will actually happen. But the topic is also a fitting one for the Kirby lecture, because it allows me to pay tribute to the groundbreaking work that Michael Kirby has done himself on this theme of access to medicines and international law. And Sally mentioned this already. So I'd like to take a moment just to list a few of his contributions. In the early 80s, Michael was invited to join the World Health Organization inaugural Global Commission on AIDS. He subsequently served on the Ethics Committee of the Human Genome Organization and on the International Bioethics Committee of UNESCO. And in that role, he chaired the drafting committee for UNESCO's Universal Declaration on Bioethics and Human Rights. He was a member of the Global Commission on HIV and the Law, an independent body convened in 2010 by the UNDP, and a chapter of its 2012 report addressed the topic of intellectual property and access to essential medicines. And he was a member of the UN Secretary General's high-level panel on access to medicines, which reported in 2016 on, amongst other issues, the interrelation of TRIPS and access to medicines. And in all of that work, Michael Kirby has consistently emphasized the need to reform intellectual property laws and to make full use of the flexibilities available in the TRIPS agreement to address the HIV/AIDS pandemic and more broadly. And I'll come back to talk about those flexibilities a little later. In a foreword to Matthew Rimmer's book, Intellectual Property and Biotechnology, published in 2008, Michael wrote, "The old empires might have faded away, but at conference after conference, I heard delegates from poorer countries proclaim that intellectual property law, as it was advancing in the world, would strangle the poorer nations. It would put them in perpetual thrall to the pharmaceutical corporations of the wealthy states. At the present moment," he ended, "in human history, it's unfortunate that we have not had the time, the will, or the imagination to think freshly about the intellectual property regimes that would be suitable for the astonishing advances that are occurring about us." So in this lecture, I want to take up this call to think freshly about the intellectual property regimes that will be necessary in these times, both of astonishing advances, but also of considerable challenges. So the immediate context for the lecture, as Sally mentioned in opening, is the vital battle that has been playing out over the past 18 months at the WTO over the temporary waiver of intellectual property rules related to COVID-19 vaccines, treatments, and technology. In October 2020, already almost a year into the pandemic, India and South Africa proposed the temporary suspension of aspects of the TRIPS agreement. And that proposed temporary waiver had a broad scope, covering diagnostics, treatment, and vaccines relating to prevention, containment, or treatment of COVID, and encompassing all relevant intellectual property, including not only patents, but also copyright and undisclosed information or trade secrets. And that proposal was co-sponsored in the end by 64 governments, supported by over 100. It was publicly backed by more than 400 civil society groups, including Amnesty, Human Rights Watch, Médecins Sans Frontières, and Oxfam, as well as the World Health Organization, UNAIDS, and over 170 former heads of state and government and Nobel laureates. Yet the waiver was blocked by a small but powerful group of WTO members, with the European Union, the UK, and Switzerland remaining staunch opponents of the proposal to the end. So the broad waiver proposed by India and South Africa was effectively displaced in October 2021, when the EU put forward a counter proposal to the WTO focused on clarifying and streamlining existing flexibilities in the TRIPS agreement relating to compulsory licensing. So I'll come back and talk more about those flexibilities, as I've said. But as Human Rights Watch noted in December 2021, the opposition of powerful states to the proposed waiver has been met with concern by a range of UN treaty bodies, UN special procedures, and the World Health Organization, and it has led to a worldwide campaign for a people's vaccine. So this month, 3 years into the pandemic, that's killed at least 15 million people, a compromise of sorts was reached at the 12th Ministerial Conference of the WTO in Geneva, On 17th June, the conference approved a ministerial declaration on the TRIPS agreement, a ministerial decision, which reflected the EU counter-proposal, I'm sorry to say. So the decision waived no intellectual property rights. Instead, it purported to clarify the situation in which states could use compulsory licensing provisions. And it was far more limited than the waiver proposal. So amongst other limitations, the decision covered only patents rather than other forms of intellectual property. And as a series of co-authored papers by a group of leading UK IP lawyers pointed out, there were significant stakes to this shift away from the Indian and South African proposal. As Siva Tambassetti and her co-authors show, it was important that the initial waiver covered a wide range of technologies, not just patent rights, but also, for instance, trade secrets, because of the thicket of patents and other forms of IP that protect these medicines. The decision also only concerned vaccines, not diagnostic tests, treatments, and other health technologies. So members kicked that can down the road for another 6 months, deciding to decide, as only international lawyers can do, on this issue within the next 6 months. And this matters because now that wealthy countries have secured enough vaccines, a new battleground has opened up over access to rapid diagnostic tests and oral antivirals. The decision only applies to developing country members, which means it doesn't address the situation faced by WTO members that are not developing countries, but in theory have access to TRIPS flexibilities. And the decision also includes a somewhat Orwellian first footnote, designed in part to placate concerns on the part of the US that China might gain an advantage from this decision. So that footnote reads, inter alia, developing country members with existing capacity to manufacture COVID-19 vaccines are encouraged to make a binding commitment not to avail themselves of this decision. So overall, as the Medicines Law and Policy blog commented, if the TRIPS decision contributes to nudging companies to share IP and manufacturing know-how in the future necessary to produce important medicines and vaccines, it may not all have been in vain, but we are scraping the barrel now. So much discussion about the impasse at the WTO and the resulting scraping of the barrel has quite properly focused on the spectacle of wealthy states prioritizing the monopoly rights of their powerful pharmaceutical companies over public health in the rest of the world. And the optics of that battle were, of course, bad. The small group of countries opposing the waiver collectively secured most of the estimated available production of vaccines for 2021 and 2022, vaccinating and then offering boosters to healthy young adults, stockpiling more vaccines than they used, and donating vaccines that they grabbed but been unable to use to other countries only when they were close to their use-by dates. The Economist was already predicting in 2021 that many people in the global south would not be vaccinated until 2023, a prediction that now seems optimistic. In April 2022, the Committee on the Elimination of Racial Discrimination released a statement on the lack of equitable and non-discriminatory access to COVID-19 vaccines. And that statement expressed the committee's deep concern that the vast majority of COVID-19 vaccines have been administered in high and middle income countries, and that as of April 2022, only 15% of the population of low income countries have received even one vaccine dose. And they said that this created a pattern of unequal distribution within and between countries that replicates slavery and colonial era racial hierarchies. So despite the strength of such critiques, because of the fragmentation of international law, much of the debate about the WTO stalemate largely treats the existence of the TRIPS agreement and the property rights it enshrines as givens, and seeks to use human rights to mediate, to come in behind and mop up the worst excesses of the resulting global intellectual property regime. But as the American legal realists taught us, property rights structure our societies. Property creates legal relations among persons with respect to things. Intellectual property creates legal relations among persons with respect to abstract things, which in turn allow rights holders to control access to many more material things. So defining property rights and their limits involves hard choices. Even liberal capitalist states don't always privilege property rights over all other interests and values. And in international law, we might think of the gradual emergence of norms prohibiting slavery, apartheid, and the use of force to collect debts as just some examples of moments at which international law limited the right of property holders in situations where those rights conflicted with other fundamental values. So the values at play in how we define property are not things that can be added on later after property law has done its work. They must be addressed as a central part of the property law regimes we create, maintain, and defend. So seen in that context, I want to suggest that the TRIPS agreement is and was a revolutionary agreement. It sits uneasily within a regime ostensibly committed to free trade. It was hugely controversial when it was signed, and I was teaching here at the ANU. And it was agreed upon in circumstances that have fundamentally changed. So for international lawyers, I hope you're pricking up your ears, we'll come back to that. And it's seen by many today as illegitimate. So I want to take the opportunity offered by this moment of renewed focus on the nature and effects of the TRIPS agreement to argue that the COVID waiver debate is a symptom of a broader problem with the global regime of monopoly rights that the TRIPS agreement established in 1995. And in this moment of disruption and change, both at the WTO and in the international legal order more broadly, I want to call for more disruption and change. So I want to suggest that the TRIPS agreement should be a serious candidate for termination. And in doing so, I want to make the bigger claim that it's time to begin thinking in new ways about the desirability and need for change in and through international law. And I'll come back to this at the end. But given the challenges that lie ahead in a world being remade by climate change, we as lawyers are going to need to welcome and manage change in the law rather than automatically seeing it as a threat. So there's the arc of the argument. In order to explain why I'm making that claim, I think it would be useful to give a brief sketch of the key provisions of the TRIPS agreement that are relevant to this debate. So the agreement, as most of you would know, came into effect in 1995 as part of a broad new suite of trade agreements resulting from the Uruguay Round of multilateral trade negotiations that led to the creation of the WTO. And those agreements were treated as a single undertaking, a point I'll come back to. But in brief, this meant states had to sign on to all the agreements if they wanted to join the new WTO. So there are four key aspects of the TRIPS agreement to note. First, it requires states to provide for minimum standards of intellectual property protection, covering copyright, trademarks, geographical indications, industrial designs, patents, protection of plant varieties, and protection of undisclosed information and trade secrets, amongst others. And the particular area of controversy here has been that of patent protection, which is required under Article 27 of TRIPS for a 20-year period. And that was a longer term than existed in most states if they patented things like medicines at all. Second, the concern that this might have a detrimental effect precisely in the way that we're seeing now in the context of the COVID pandemic was in theory addressed by the inclusion of flexibilities in the agreement, flexibilities in relation to each of the different forms of property right. So for instance, in the case of patents, this would include compulsory licensing, the possibility of providing for compulsory licensing of a patent without the authorization of a rights holder in the case of an emergency. And this was arguably informed by the objectives and principles of the agreement, which provided that the protection and enforcement of intellectual property rights should be conducted in a manner conducive to social and economic welfare and to a balance of rights and obligations, and that members may adopt measures necessary to protect public health and nutrition. Now, whether those discussions of objectives and principles are understood to be a description of what happened in the past when the agreement was negotiated, or what should happen in interpreting the agreement, has remained a sore point ever since. And the article also includes a provision on security exceptions, which some have argued could also apply in the context of a pandemic. Third, the agreement deals with the enforcement of intellectual property rights domestically in great detail. So states must implement enforcement procedures, which are not to be unnecessarily complicated or costly, or entail time limits or unwarranted delays. Decisions about intellectual property are to be in writing with reasons. Rights of judicial review are to be provided, and states are obliged to provide criminal procedures and penalties, at least in the case of willful or widespread counterfeiting or piracy, and the remedies to be available under criminal procedures are to include imprisonment or monetary fines sufficient to provide a deterrent. So as Michael Trebleco and Robert Howes, two trade lawyers, noted in 1995, those provisions created an unprecedented degree of control by an international regime over domestic civil and administrative procedures. And they represented, in their words, a massive intrusion into domestic legal systems, and especially the balance that those systems strike between the rights of defendants and those of plaintiffs. Developing countries had hoped that technology transfer would be mandatory under the agreement. It is mentioned as something to be encouraged, but there is one form of mandatory provision of technical cooperation for which the agreement provides, which in my view does put the icing on this particular cake, and that is that states must provide technical and financial cooperation to developing and least developed country members to facilitate the implementation of the provisions relating to protection and enforcement of intellectual property rights. And fourth, dispute settlement is then provided for in relation to the TRIPS agreement under the WTO dispute settlement system. And this meant that states with strong IP interests gained a lot of leverage as a result of the agreement. So, for example, whereas banning the imports of Australian computer software might not do a lot to stir trade officials in Australia, I'm sorry if those in the audience are computer programmers from Australia, but putting large tariffs on Australian agricultural imports would cause a response. So that kind of cross-sectoral retaliation is possible under the dispute settlement understanding, one of the agreements negotiated as part of the Uruguay Round. I'd also note in passing that states seeking to join the WTO after its creation must also negotiate protocols of accession, setting out additional obligations that are required of them by the existing members. And in the case of China, for instance, this involved additional obligations relating to intellectual property, where China agreed not to require technology transfer as a condition of access to its market. The attempt to stop what the US now calls forced technology transfer by Chinese entities entering into joint ventures with foreign companies is one cause of the trade war initiated by the Trump administration in 2018. So there's a picture of the kind of core of the TRIPS agreement. So why would I say that this is revolutionary? So it's revolutionary, in my view, both in terms of existing intellectual property regimes and in terms of its relation to the trade regime. So if we start with intellectual property has a long history in industrialized countries, and the design of patent laws in particular has been a complex political exercise. Because patents create property rights in knowledge about inventions and give the patent owner monopoly control over the physical production of material objects derived from those inventions for a limited period. So they are and have always been seen to be monopoly rights. So states traditionally designed their patent laws to achieve a balance between a series of goals: rewarding inventive work, enabling the spread of knowledge useful to society, ensuring inventions were available for widespread productive use. And the balance could be met in different ways. For example, by granting patent holders the right to exploit their invention for a limited, usually reasonably short term, by requiring that the patent be worked or exploited within the territory of the country granting the patent, absolutely vital to preventing a patent just sitting there and being used to create a monopoly, a market. Third, ensuring the invention was published in a manner that allowed others to learn how to use it, what we might now call forced technology transfer. And finally, limiting the nature of inventions over which patents could be granted so as not to include essential commodities. And on this note, many European countries refused to grant patents over medicines until well into the 20th century. For example, 1967 in France, 1978 in Italy, 1992 in Spain, even in Switzerland, pharmaceutical powerhouse, one of the states very strong on rejecting this waiver, didn't have drug patents until 1977. In addition, industrialized countries in the process of industrialization always limited the scope of protection granted to foreign technologies, often excluding whole areas of activity from protection. And the theory was that if a country has a weak technical capacity and local enterprises aren't able to take advantage of incentives provided by monopolies, it doesn't make sense to offer strong patent protections to foreign technologies unless you want to encourage foreign inventors to come and live in your country. So while originally designed as a means of fostering technological and industrial progress of the state granting the patent, there has been a trend towards internationalizing intellectual property rights. So there's a longer story to tell about that than can be told at the end of a conference day. So let me just say that this was largely dealt with under the World Intellectual Property Organization, or WIPO, which administers, amongst other things, the Paris Conventions on Industrial Property and the Berne Convention on Copyright. But that was seen to be leave too much scope for countries still to decide how to protect property. And so the impetus for shifting intellectual property protection from WIPO to the WTO began in the 80s. And here it initially was driven by corporate America, by companies like IBM, like Microsoft, and also FASSA. So the US government was very receptive to lobbying on this issue. It had become sensitive to fears over the loss of US competitiveness. At the time, the concern was, I can remember this sadly, Asian tigers and the Japanese miracle economy. We can kind of substitute China in for them now. That was basically the same kind of argument. And there were also a number of significant developments within the US. One was the famous decision in Diamond and Chakrabarty of the Supreme Court, in which the Supreme Court infamously wrote that anything under the sun that is made by man is eligible for patenting. But that was also the year in which the Reagan administration passed the Bayh-Dole Act, which really changed the political economy of biomedicine for universities really everywhere, I think, following that. And this was the context in which the US began a campaign working with Pfizer and other major US companies to introduce this new US-style patent system on a global scale. And the negotiation of the TRIPS agreement was one of the most important achievements of that campaign. The genius of the approach was to link intellectual property rights with the enforcement mechanisms of this new trade dispute settlement system. So that's why I think the agreement is revolutionary from an IP history perspective, but it's also revolutionary from a trade perspective. The global regime of intellectual property rights is in many ways conceptually at odds with a free trade regime. Prior to TRIPS, intellectual property rights had not been successfully linked with trade law. Indeed, when states like the US began to push to have intellectual property added to the Uruguay Round, many trade negotiators and the GATT Secretariat itself had little familiarity with intellectual property regimes and saw a conceptual tension between free trade and the monopoly privileges that intellectual property rights present. Indeed, as historians of intellectual property remind us, some of the most powerful critiques of intellectual property during the 19th century could be found in the pages of the famously still free trade magazine, The Economist, whose editors were vehemently opposed to the English patent system and its creation of monopoly rights. The dissonance between a free trade regime and a regime of intellectual property rights is even clearer when the intellectual property regime is globalized. So as Peter Drahosch, long of ANU, now at EUI, notes, a patent right or a copyright is a property right over an abstract object that gives the owner the power to determine the physical reproduction of that object. So it creates monopoly privileges over the reproduction of physical objects. And those monopoly rights are further strengthened under a global property regime. Any weakening of the obligation to exploit a patent in all countries where it's granted can lead to patents simply working as means of creating exclusive rights over export markets in goods and services. Exactly what we're seeing in the context of manufacturing, diagnostics, antivirals, and vaccines. So the story I've told so far explains why the US and the EU and Japan were enthusiastic about the TRIPS agreement. It doesn't explain why anyone else would sign on to it. And that really needs explaining because TRIPS was a particularly bad deal for almost every state. Most states had nothing to gain and much to lose from signing it. Most countries other than the US were net importers of technological and cultural information, and all were therefore persuaded to pay more for that information. And in turn, the lack of a requirement that patents be worked also meant that many states were accepting the creation of exclusive rights over export markets. So why did states sign on to TRIPS? Why did states do a lot of things? This is a difficult question to answer, but there's been a lot of research into this. Again, Peter Drahosch and John Braithwaite leading the way, as well as Susan Self. So a very ANU story. Okay, so here's 3 reasons I would say that states signed on. First, they did so because it was part of a broader package. The wide-ranging agenda of the Uruguay Round negotiations meant that a loss in one area could be turned into a win in another. So the phrase single undertaking was initially used in the Punta del Este Declaration, launching the Uruguay Round. By the end of the round, the insistence on the resulting agreement as a single undertaking was used to close the negotiation and secure the overall bargain. And the final act of the Uruguay Round states that the WTO agreement shall be open for acceptance as a whole. And Article 14.1 provides ratification applies to the 17 Uruguay Round agreements in the annexes. Members could not pick and choose among the treaties, and reservations were not allowed. And by 1999, the panel in Korea dairy products could hold that it is now well established that the WTO agreement is a single undertaking, and therefore all WTO obligations are generally cumulative, and members must comply with all of them simultaneously. Second, in a related point, states that joined the WTO undertook to resolve their trade disputes through a newly created dispute settlement mechanism overseen by an appellate body. You might know where I'm heading. The willingness of the US to submit its complaints to that system rather than continue its heavy-handed use of unilateral sanctions and trade remedies was a significant factor in the decision of many states to sign on to the WTO agreements. So in the lead up to and during the Uruguay Round, the US had made the aggressive use of its Section 301 of its 1974 Trade Act, and then the new Super 301 of the 1988 US Omnibus Act. And those provisions set out the basis. I've left something out, it's not just a act about omnibuses, it's about Omnibus Trade and something act, but you know where I'm going. So these provisions set out the bases on which the US would take action unilaterally in response to a broad range of trade barriers and what the administration defined as unfair practices. And this very often included intellectual property violations in the view of the US. And it was an objective for most countries in the last phases of the round to limit the ability of the US to invoke those provisions. And this was reflected in Article 23 of the Dispute Settlement Understanding, in which states undertake to resolve disputes by recourse to the Dispute Settlement Understanding rather than unilateral remedial action. And in addition, the agreement establishing the WTO provides that each member shall ensure the conformity of its laws, regulations, and administrative procedures with its obligations as provided in agreements. So read together, that provision, Article 16 and Article 23 of the DSU require that states don't have in place laws, regulations, or procedures that allow for unilateral retaliatory measures to address perceived violations of trade agreements. So the willingness of the US to sign up to a compulsory multilateral dispute settlement system was closely tied both to the whole WTO package, but also to the adoption of TRIPS in particular. So the Section 301 provisions were used by the US during the Uruguay Round negotiations to pressure states to accept the inclusion of the TRIPS agreement within the WTO covered agreements. And even resistance to US negotiating objectives at multilateral fora could trigger states being added to the Section 301 watch list by the US. So this meant that there was little resistance to the TRIPS proposal by the time it got to the later stages of the Uruguay Round, because numerous states had been targeted by that approach. And the third reason that states were willing to sign on to this was, as I've mentioned already, the promise of flexibility. So states signed on to the agreement because they understood that it included a set of exceptional measures that they could take in the event of a public health emergency, including the capacity to issue compulsory licenses, allowing someone other than a patent holder to manufacture a patented product. So we could leave the story here and say that was a really bad bargain. So the answer simply could be the US and the European Union won in 1994, everyone else lost, and now people in other countries have to be sacrificed to uphold these property rights in perpetuity. So here we need to talk about termination. When I began teaching international law in the early 1990s, I have to admit that I didn't pay much attention in treaty lectures to rules relating to termination and withdrawal. And when I moved to Canberra to take up a position teaching international economic law at ANU in 1995, I didn't imagine that the shiny new WTO would really ever come under meaningful challenge. Fast forward to 2022, and it would be impossible, I think, to teach an international law course today that doesn't discuss the legal effects of unsigning, withdrawing, suspending, or terminating treaties. Even the once arcane doctrine of rebus sic stantibus is now undergoing a renaissance, we're told, according to one author, and I'll come back to that in a minute. International lawyers, in my reading, have a tendency to think about this moment of withdrawing from and terminating treaties as a bad thing, as involving a threat to the international rule of law, and we often hear it described in those terms. And I want to suggest that we need to start thinking in a more positive way about this process of termination and withdrawal, particularly in light of the rapidly changing international order that will result from the material and geopolitical transformations caused by climate change. And COVID may be one of them. So in domestic law, of course, we understand that contracts can be terminated, cases can be overturned, and legislation can be reformed. And indeed, if we look at the IP system on which TRIPS was modelled, we find that the US domestic legal system has indeed begun to walk back this absolutist and expansive notion of IP rights. Indeed, by the early 2000s, there were already widespread agreements amongst lawyers and economists that the effect of this overly generous approach to patentability was creating uncertainty, increasing information costs, and decreasing innovation because of, for instance, the practice of patent trolls, who would just opportunistically patent all sorts of things very vaguely, hope that some of them would stick, and then try and get people to pay them licenses in order to continue with their research. So the pendulum in the US is beginning to swing back. So the only field in domestic law in which we don't feel so comfortable about legal change is constitutional law. But should lawyers treat a treaty like TRIPS as if it were a constitution? So when legal documents are the product of a great democratic assembly gathered together to draw up a constitution or even perhaps a piece of important legislation, then the reluctance to reopen those texts might be understandable, although I would be reopening them in the United States. But the TRIPS agreement is not such a text. So of course, international law does provide mechanisms for terminating or withdrawing from treaties. Most treaties will contain a provision addressing those issues, and if not, we fall back on the Vienna Convention on the law of treaties and the broader doctrines of customary international law that it developed and codified. So the TRIPS agreement itself has no clause relating to withdrawal or termination. States seeking to withdraw from the TRIPS agreement could withdraw from the WTO, as per Article 15 of the WTO agreement, which provides any member may withdraw from this WTO agreement. Such withdrawal shall apply both to this agreement and multilateral trade agreements. But there may be very good reasons why states don't want to withdraw from the whole of the WTO or most of the other covered agreements. As I've said, the TRIPS agreement is a very different beast. So this, then, I would like to suggest throws us back to general treaty law. Let's kind of just do a mental experiment with this. And in particular, I want to look at one potential means of adjusting or terminating treaties, the doctrine of fundamental change of circumstances, or rebus sextantibus, included in Article 62 of the Vienna Convention on the Law of Treaties, although in negative form, may not be invoked unless. So according to Article 62, the grounds for invoking fundamental change of circumstances for terminating or withdrawing from a treaty involve where a fundamental change of circumstance has occurred with regard to circumstances existing at the time of the conclusion of the treaty. It was not foreseen by the parties. The existence of those circumstances constitute an essential basis of consent for the parties to be bound by the treaty. And the effect of the change is to radically transform the extent of obligations still to be performed. And the International Law Commission explained the conclusion of the provision in the Vienna Convention, or in the draft articles that led to it, as follows. A treaty may remain in force for a long time, and its stipulations come to place an undue burden on one of the parties as a result of a fundamental change of circumstances. Then, if the other party were obdurate in opposing any change, the fact that international law recognized no legal means of terminating or modifying the treaty, otherwise than through a further arrangement between the same parties, might impose a serious strain on the relations between the states concerned. Failing any agreement, one party may be left powerless under the treaty to obtain any legal relief from outmoded and burdensome provisions. It is in these cases that the rebus sextantibus doctrine could serve a purpose as a lever to induce a spirit of compromise in the other party. So I'd suggest that this is the situation facing those states that are confronted with parties who are obdurate in opposing change to the TRIPS agreement, or even using the extent of its existing flexibilities. And in order to make a case for the relevance of the doctrine, we could think again about the circumstances in which states signed the agreement and that constituted an essential basis for their consent to be bound. It was a single undertaking, part of a single undertaking that importantly involved a sophisticated dispute settlement mechanism. The United States has effectively blocked the operation of that system as negotiated. Second, commitment to not taking unilateral actions. the commitment of the US to abandon unilateral actions was central to the consent of many states to the WTO package in general and the inclusion of TRIPS in particular. And the US has walked away from that commitment. It has reinstated actions under Section 301 provisions with a vengeance. And third, flexibilities. Attempts by states to utilise the supposed flexibilities built into the TRIPS agreement have been routinely met with the threat of expensive litigation at the WTO and by other forms of investment arbitration and domestic cases. In addition, the TRIPS provisions require member states to engage in lengthy negotiations with empowered patent holders who continue to show little interest in meeting governments halfway. And the COVID pandemic has provided numerous instances of this, including at the moment involving Pfizer taking action against the Dominican Republic for its use of a compulsory license to manufacture a generic version of the antiviral Paxlovid, which is relatively straightforward to manufacture, store and distribute, and will otherwise be unavailable in much of the world until at least 2023, because Pfizer has run out of manufacturing capacity. Finally, states are now faced with unstable natural conditions that have radically altered even since the TRIPS agreement was signed in 1994. And a number of international environmental lawyers, including Karen Scott, have begun to speculate about the role of rebus sic stantibus as a doctrine that might offer a means, in the words of Diane Reisman, of adjusting treaty regimes in an orderly fashion in the context of a rapid and massively changing climate in which the balance of interests of state parties to numerous existing treaties may very well not survive. So to conclude, the current push for a waiver has been made to seem radical, and yet I want to suggest it simply involves returning to a default position that was dominant only 25 years ago. Many arguments opposing the TRIPS waiver are at the very least contested, including the claim that patents are necessary to recoup costs when much vaccine development relied on public funding, or that medical researchers would not innovate if it were not possible to make enormous profits. All of that would be contentious at any point, let alone during a global emergency. Leaving weighty decisions about the manufacture of and access to medicines to a handful of private companies is an effect of a legal system that gives those companies historically exceptional rights to control production anywhere in the world. The fact that they now have those rights in turn gives them resources with which to lobby regulators, and they have done that from the very start of the pandemic. International law in the form of TRIPS plays a constitutive role in creating those rights in knowledge about pharmaceuticals, which the holders can then use against others. It turns knowledge into a scarce asset, and in so doing, creates control over the objects produced as a result of that knowledge. The terms on which some of the proponents of this global regime for protecting intellectual property rights defend this model can easily draw us into a simplistic debate. So in that debate, being for the TRIPS agreement is to be for innovation, and being against the TRIPS agreement, or even seeking to use its flexibilities, is to be against innovation. And that's simplistic because it's hard to say in the abstract whether a strong intellectual property regime in a field such as biomedicine is a necessary condition of innovation or even conducive to innovation. So there's a broad literature in the law and economics of intellectual property debating whether or not this link between invention and property can really be made out. And that's in part because, as Graham Dutfield puts it, intellectual property law is a system that is complex and highly contested, involving rules and exceptions, regulations, judges, patent officers, patent attorneys, political lobbyists, consumer groups, big corporations, small inventors, and public sector researchers. Not all pharmaceutical companies or inventors have the same interests. some may benefit from strong patent rights protection, but for others, those rights impose significant costs. For example, when basic research tools such as DNA sequences are patented. Using the global patent system is expensive, with high costs involved in asserting and defending patent claims. So that suits big players. It can also make it easier both for big players and small players to act in predatory ways, as I mentioned earlier, lodging patent claims to block competitors, staking claims to the intellectual property of independent inventors or Indigenous knowledge holders who can't afford to take legal action to defend themselves. Or, as I said, in the case of patent trolls, registering broad claims of doubtful validity to extort payments from those seeking to undertake research. The intellectual property system is also called upon to balance competing values, such as offering financial rewards to rights holders, but also encouraging technological progress and realizing public goods, such as protecting public health or limiting climate change. And innovation may depend as much upon imitation or building upon existing knowledge as upon invention or the application of new knowledge. So suffice to say that determining what kind of intellectual property regime will best encourage and enable innovation, let alone those other competing purposes and values, is very context specific. In such a situation, democratic participation in decision-making about these competing values and purposes is essential. So the good news is that what international law gives, it can also take away. TRIPS is a flawed agreement that should never have been part of a trade regime. Most states did not sign on to it because they were persuaded by the claims underpinning the arguments of pharmaceutical lobbyists, or that they believe fervently in the primacy of property rights over all other public goods. Maybe some of them do, but not most. So they signed on to the TRIPS agreement as part of a larger bargain. So now the circumstances in which states have made that bargain have fundamentally changed. The US has torn up its part of the Uruguay Round deal. Resort to the meagre flexibilities of the TRIPS agreement has been systematically constrained by Western powers and big pharmaceutical companies. The WTO as an organisation has proved unable to balance intellectual property rights and public health needs during a global pandemic, as the years-long debate over that waiver illustrates. And as a result, transnational alliances opposed to the current system are gaining visibility and influence. So in my view, in that context, it is time for states to terminate the TRIPS agreement, and it's time for lawyers to take up the challenge posed by Michael Kirby and to imagine intellectual property regimes that are capable of responding to the challenges that lie ahead. Thank you.
One of the consequences of growing old is that if you're around for a long while, you tend to get things named after you. Tonight brings together two things named after me, of which I'm inordinately proud. The lecture that is sponsored by the ANU and the chair that Anne Orford, our lecturer, has accepted, and which does me great honour. I've also had other things named after me. I've had dogs and cats and even human children. But tonight is a special night for me, and I want to express particular thanks to Anne Orford for a wonderful lecture. It wasn't, as you will have noticed, something that was simple, straightforward, and that can be comprehended easily if it's something that is new to you. I became involved in the HIV pandemic because it was a pandemic before the COVID pandemic, as a result of a visit to Australia of a very great international civil servant, Jonathan Mann. He later was appointed to be the first director of the Global Commission on AIDS and the Global Program on AIDS, GPA. And for that purpose, he was taken from Brazzaville in French Congo up to Geneva, and he worked there, and he came out to Australia. And with a number of professors, I was invited to a dinner with him, and I met him. And that led later, I think because I held a judicial title, I think that was the bait that made Jonathan Mann think, well, we'd better have somebody terribly respectable on this pandemic, because it was a pandemic that involved a lot of very vulnerable people, men who have sex with men, sex workers, injecting drug users, prisoners, people who presented real difficulties in getting an international response. And the result of the work of the Global Commission on AIDS and of the other activities of Jonathan Mann before he had a bust-up with Mr. Nakajima, the Director General of the World Health Organization. The net result of it was that a recommendation was made to the global community at a time when there were no curative drugs, that the only thing we can do is to reach out to the affected populations, remove the laws against them, and try in that way to encourage them to take our advice and do certain things and protect themselves and thereby protect the whole community. Only 2 countries immediately followed that. The first was New Zealand. They're a feisty little country, New Zealand, but they often do things first. They're wonderful, including on nuclear weapons and controls. Their leaders, we have rather tended to drag the chain. But the result of the effort was that UNDP, the United Nations Development Programme, set up an inquiry to which I was appointed, which sought to look at the law as it affected the pandemic of HIV/AIDS. And it found things where the law was a real impediment, such as the law on homosexuals, the law on sex workers, the law on drugs, and so on. But it also found that there was an area of the law little considered by most people who are in the HIV field, which was extremely important. And that was the law of intellectual property. Because although the Global Commission was established in 1989, and I was appointed to it then, the development of the antiretroviral drugs with the so-called triple combination therapy, they found that if they mixed up these drugs that had been developed for other purposes and combined the 3 major drugs, that would have not a curative effect, because we've never found a cure for HIV, but a greatly palliative effect so that people could live their lives without risk to others and without risk to themselves. This was treatment effectively as control, and it was extremely important. But as the antiretroviral drugs became really important, intellectual property law and the TRIPS agreement became important in tandem. And when the original triple combination therapy came along, to get access to the triple combination therapy, the original prices were about $1,000 a year. And most people in the developing countries talk about a racial discrimination in international law and international politics, could not pay that. And two countries in particular couldn't pay it, but they did have sufficient skill, scientific skill and manufacturing skill to be able to deconstruct the drugs, find out what they were made of and reproduce them. And those two countries were India and Brazil. Very big countries, very big HIV pandemic, and constitutional requirements that obliged their government to look after the health of their people. And they said, we are going to do this. The result of that was, on the front pages of the New York Times, was a scoffing remark by the then American president and the then officials that there's no way, with all respect to India and Brazil, that they could do it. But Brazil had a very feisty president, Lula. He's a candidate to come back now. And he said, we are going to send first-class tickets to take the leaders of the American industry and manufacturers of the drugs to come down and see our country, to come along and see our laboratories. And then they can talk about whether we can do this or not. And lo and behold, the manufacturers and representatives of government went down there, and to their amazement, they concluded that this could be done by Brazil and by India and by other countries. Now, under a lot of pressure, India later changed its intellectual property law, which made it difficult for them to do this. Pressure is the name of the game. And the net result of this was that in India, before they changed their intellectual property law, the price of getting access to the triple combination therapy came down from $1,000 a year down to about 100, and then even lower and smaller, and they could afford it. And that turned their epidemic round. Likewise in Brazil. And this demonstrated the unfairness of the TRIPS agreement and of the way in which Section 301 was used to put countries on the blacklist. And that has immediate bad consequences for those countries. The net result of it is if you're on the US blacklist, your trade with that country is with the United States is really undermined. And so it's not just a theoretical thing, it's something really urgent, important, and immediate. But everybody then got in on the act. The Global Fund on AIDS, malaria and tuberculosis, UNAIDS, UNDP, everybody started to look at this. And in a report to which I contributed for UNDP, we said the Secretary General should set up a body, an interdisciplinary body, to find solutions that can be incorporated into the TRIPS agreement and can help countries under that agreement, the TRIPS agreement, to make their own drugs in the event of a national health emergency. Not an unreasonable idea. And so we had our meetings, we delivered a report, we had a wonderful committee. It wasn't specifically a WHO committee, it was a UNDP committee, development. And the chair of the committee was Ruth Dreyfus, who had been the president of the Swiss Confederation, and also the president, the co-chair had been the president of Botswana. And they were magnificent leaders, and they urged that steps should be taken to modify the TRIPS agreement, and that led to recommendations to the Secretary General, and that is where it was left when Ban Ki-moon demitted office. Now, Ban Ki-moon was a very unusual man. He was a Korean diplomat, but when he got into the office of Secretary General, he really flourished, and he appointed, or he knew, and I took part in the inquiry into North Korea, and that is something on the minds of every South Korean. And a moment happened one day in the UN headquarters in Geneva. This would have been about 2015 or 13 maybe, when I was going up an escalator and Gareth Evans was coming down an escalator, not Gareth Evans, and James Crawford was coming down an escalator. James Crawford was being taken around to be inspected for consideration for election to the World Court. And I went up the escalator and I said, "Hello, James." And he said, "Hello, Michael, good to see you." And he went up to fame and fortune as a judge of the World Court, sadly to be struck down later. I went up in the lift to the top floor of that building, that great graceful building at the foot of 42nd Street, which is where the Secretary General's office is. And I was ushered into the presence, and then somebody came in to take photos, which are very regular. They've got the UN wonderful logo and the map of the world and so on. And I went forward with Ruth Dreyfus and with the President of Botswana. And I went forward because I had been the chair of the advisory technical committee. With that, people leapt forward to drag me out of the photo because this was only for presidents and not a mere judge from Australia. But the Secretary General came to the rescue because he knew me from the North Korea inquiry, and he pulled me back. It was somebody official was pulling me this way and pulling me that way. But I went back into the photograph, and lo and behold, that is how we appear on that occasion. But as Anne has explained in her lecture, there was then another pandemic, and that other pandemic demonstrated more urgently and immediately the real problem of having drugs and tests and therapies which are the subject of intellectual property, which countries will seek to enforce. Section 301 will seek to enforce, and that is where we are in the world now. And that's why the issue that Anne has explored tonight is so important and so urgent. And I remember that the Australian government, at a meeting I went to here in Canberra, was very proud of the Australian contribution to the Trans-Pacific Partnership Agreement. And somebody said recently, I think it was somebody in the then opposition, now the government, that the coalition had mucked up the we should fix that up and join the Trans-Pacific Partnership Agreement. Well, I'm with Anne. I think that would be a very bad thing, because that's still more ammunition to try to prevent countries fulfilling their own constitutional and moral duties to protect their own citizens in cases of desperate international global health crises. So, boy, we've had a wonderful lecture tonight, and it's been on a subject which is right up there as one of the really big moral questions of the day. What are they? Nuclear weapons. Unless we control that, unless international law can come to our rescue, it can all be over quickly. And if you've been watching Al Jazeera and other news on Mr. Trump smashing the ketchup on the wall, this is the man who has his finger on the nuclear buttons. I mean, this is a terrible, shocking and urgent thing. So that's the first. The second is global climate change. And the third, I think, is pandemics, because we haven't seen the end of COVID and we haven't seen the end of pandemics. So I want to thank Anne for a really topical, technical, detailed lecture, which will repay careful study, and I hope will get into the hands of the many very distinguished representatives of the Commonwealth of Australia and the bureaucracy of our country, so that they will get it, read it, and inwardly digest it, and lay off trying to get us to sign the Trans-Pacific Partnership, and lay on to us being a leader, like New Zealand often is, in the sorts of steps that Anne has suggested in her wonderful lecture. We should give her, as citizens of Australia, a really big round of applause for such a wonderful lecture, appealing to us as Australians for once to be a leader in a great moral issue and a great legal issue. Thank you very much, Anne Orford.